I'm Carla Murray. I'm a partner and I head the commercial team here at Meyerson. I also head up our tech sector and I specialise in non-contentious intellectual property. I am joined today by my colleague Richard Meehan. Richard is a senior associate in our commercial team and he heads our life sciences sector, and Rich also specialises in non-contentious IP. And finally, we're joined today by Robert Brothers. Rob is a senior associate in our dispute resolution team and specialises in trademark and other IP disputes. So on the slide today, I've set out what Richard and I would like to cover over the next 30 minutes or so. And we have 4 main aims for today's session over the areas we're covering. And what we'd like is for you to go away with an understanding of what intellectual property rights are, what they do, so you can gain a deeper understanding of how and why they're important to your business. We want to help you to be able to identify what intellectual property rights you have within your business. And finally, for you to have an understanding of the ways to protect and exploit your intellectual property. So now I'm going to hand over to Rich, who will take you through an overview of what IP is.
Thank you, Carla. There are lots of different ways of talking about what intellectual property is, but they have some common themes. There will generally be a reference to creativity, and the things that qualify as intellectual property are often referred to as creations of the mind, although it will be interesting to see how well references to the mind survive in the AI era. You also get the term intangible in most definitions, since intellectual property falls into the category of assets which exist but cannot be touched. There will generally be an acknowledgement that intellectual property rights are themselves created by law. It is only in the context of an enforceable legal system that anyone can claim ownership of intellectual property. And it is the legal systems that distinguish between the different types of intellectual property, copyright, patents, etc., and give them their definitions and rules. That does mean that there can be differences in how intellectual property rights operate in different territories with different legal systems. Another interesting aspect of some definitions of intellectual property rights is to think of them as negative rights. This focuses on the idea that what is important about owning intellectual property is not so much that it gives the owner the positive right to do something, but more that it gives the owner the negative ability to stop other people from doing that thing. The existence of that negative right allows the owner to commercialize their ownership of the intellectual property asset by exploiting it themselves to the exclusion of other people, or by requiring other people to pay them for the privilege of doing that thing. Some commonly encountered types of intellectual property are listed on this slide, and we'll look at those in more detail as the presentation goes on. We have also included confidential information on this slide. It isn't typically classed as intellectual property, but it is an important intangible asset of many businesses, and it is worth understanding how it is protected and how it interacts with intellectual property. We'll therefore consider confidential information first, before describing the key features of copyright, design rights, trademarks, and patents. As I say, confidential information is not classed as an intellectual property right in itself, but for any business interested in understanding its intangible assets, it is important to identify the information it holds and what it considers commercially sensitive. Doing this allows the business to ensure that suitable protections are put in place to prevent unintentional disclosure of the confidential information. For example, businesses can implement information management policies to ensure that the information is only available within the organization to individuals with a need to know, and that appropriate confidentiality agreements are in place before the information is shared with any partner organizations. Since confidential information is not one of the categories of intellectual property created by law, there is not a general statutory definition, although for completeness, there is a definition for the term trade secrets under the Trade Secrets Enforcement Regulations of 2018. These were UK regulations that implemented EU law back when that was a thing and remain in effect following Brexit. In either case, there are no formal requirements for confidential information to be registered in any sense. Instead, you consider the nature of the information itself.
Thanks, Rich. So we're going to have a look at copyright. So copyright is defined in the Copyright Designs and Patents Act 1988. Copyright is a proprietary right which protects certain qualifying works. So copyright can exist in recordings, films, broadcasts, software source codes, literary, dramatical, musical, and artistic works, and it covers written text, drawings, images, and even sound. My youngest daughter and I are currently working our way through the Harry Potter books, and using these as an example, they would have copyright in the manuscript, in the typographical arrangement of the text, and in the images on the front covers of the books. And then if we looked at the films themselves, there would be copyright in the film scripts, in the film recording itself, and in any soundtracks that accompany the film. So the question is then, what does copyright actually do? Well, copyright gives the owner of the works the exclusive right to publish and exploit the works. And it also allows them to prevent others from taking action such as copying the works, modifying the works, adapting or using the works, and distributing copies and the works themselves without the copyright owner's permission. So, as the copyright owner, you can actually take enforcement action against anyone who is infringing those rights. There are no formal registration requirements for copyright. It automatically arises if the particular work in question meet the qualifying criteria. And that criteria is that the works themselves must be recorded in or take a tangible form. The author of the works must satisfy the nationality and domicile requirements here in the UK, which means that the author must be based or live in the UK. So, for example, be a British citizen or just an individual living in the UK, or an employee of a UK registered company. And then the works themselves must be original. Now, originality is quite a low threshold. It just requires some skill and effort to be used by the individual and for the piece of work not to have been copied. You should note that unless the work has been completed under a contract of an employment by an employee, the owner of the copyright work will usually be the author of the works themselves. And copyright can last for different periods of time, and it really depends on the nature of the works. So it ranges from 25 years for typographical arrangements up to 70 years for literary and dramatic works. And there are three issues really to consider with copyright. Going back to the fact that copyright does not protect an idea, it will only protect the physical manifestation of an idea. If you're looking to protect the idea, that's where sort of confidential information comes into play. So for the copyright protection to come into play, the idea, as I say, itself has to take a physical form. It's also possible to have two independent yet identical pieces of work having separate copyright in them, with that copyright belonging to two different people. And this is due to the nature of copyright. Because it is an automatically arising right, it is entirely possible for two people to have the same idea at the same time and thus create independent works, both of which are capable of having copyright in them, and the copyright then belonging to each individual author as they've been developed independently of each other. And finally, there's sometimes an issue in establishing the date of the creation of the works. This can be overcome by registering the work with a copyright house, which in effect provides an independent third-party date stamp of the copyright in the work. It's evidential in nature, and there is a cost associated with this. Historically, you would have authors posting copies of the work to themselves so that they can keep that date stamped envelope to show as evidence for when the work was created. And now, obviously, in line with the modern era of the internet and online matters, there are online companies whom you can lodge copyright works with, and they will electronically date stamp those work and certify the work. But what they can't do is verify the originality or the authorship of the work. So then moving on to registered design rights and unregistered design rights. Design rights themselves, whether they are registered or unregistered, protect the appearance of a whole or part of a product. A registered design right can apply to two-dimensional designs and generally relates to the appearance of the product. So, for example, it can cover colours, patterns, and icons. And registered design rights, similar to copyright, they give the owner of the right the exclusive right to use the design and also a restrictive right to prevent others from using the design. And the concept of use is quite broad. So the right to restrict others from using the design includes the right to restrict and prevent third parties from marketing the design, importing it, producing products using the design, and incorporating that design into other products without the design right owner's consent. For the design right to subsist, as the name suggests, for registered design rights, there are registration requirements. So you'd apply to either the UK Intellectual Property Office or the European Intellectual Property Office or the World Intellectual Property Office. And which you apply to depends on how wide you want your registration to cast. The criteria for registration is that the design itself has to be novel or new. It can't be identical to a design that's already been made publicly available. It has to have an individual character itself and not be excluded by statute. Registration, however, does require renewal every 5 years, but it does mean that protection can last up to 25 years. And compared to some of the other registered intellectual property rights, it's a relatively low cost. So moving on to unregistered design rights. So even if you don't register a design, your design may itself still have protection as an unregistered design. As mentioned, as with registered design, unregistered designs protect the appearance of the whole or part of a product. And design rights do tend to be commonly used in the fashion and textiles industries. Tartan patterns are a really good example of this. Now, this is music to my ears, as on a Sunday evening, you'll quite often find me helping, or rather doing, my eldest daughter's GCSE fashion homework. And I'm now starting to wonder if not only will I get a share in her GCSE grade, but also whether I can have some claim to the designs that we are creating at our kitchen table. Although I'm pretty sure she'll argue that there's no joint authorship going on here and she is the sole proprietor of all the ideas that I somehow seem to come up with for her. So I suppose you're wondering, why is unregistered design rights needed? Well, unregistered design right protects the design from being copied or used to create an article that's exactly the same or substantially the same as the design. And they give you the right to take action against people that are infringing your rights or importing infringing products. Unlike registered design rights, there are no registration requirements. As with copyright, it is an automatically arising right if the design meets the qualifying criteria. And for that, the design has to be original. And the design itself is any aspect of a shape or a configuration, and it can be the internal or the external part of an article. And so in that's quite a wide definition. So most designs kind of fall into that broad definition. And as with copyright, the originality is quite a low threshold. It requires skill and effort to be used and for the design not to have been copied or commonplace. In the EU, design rights last for 3 years, and in the UK, the general rule is sort of 10 years from the date that the product was first marketed. I'm now going to hand over to Rich, who's going to look at trademarks in a little bit more detail.
A trademark is a distinctive word, sign, or other signifier used to distinguish the goods or services of one business from those of other traders. It can therefore be used to protect the business's brand and its associated goodwill, by which we mean in broad terms, the value of the brand's reputation in the market and its customer loyalty. That link between trademarks and goodwill is so close that the mechanism for acquiring an unregistered trademark is actually to take ownership of the goodwill that's associated with the mark. The key aspect of a trademark is its distinctiveness and its ability, therefore, to identify a particular source for products and services. The form it takes can be very wide-ranging, words and images, but also sounds, like Intel's jaunty 4-note tune and the MGM Lion's roar, smells, and even gestures, as does double tap on a back pocket, which seems to have survived the switch to a cashless society. Trademarks are one of the categories of intellectual property that can exist both in registered and also in unregistered forms. In the UK, the registration regime came into effect in 1876, and the first registered trademark was the distinctive red triangle used by Bass Brewery. Before that, a business could protect its brand names through the common law rules around passing off, and this is the regime that still protects unregistered trademarks. To succeed in a passing off claim, however, is difficult. The brand owner needs to prove their own ownership of goodwill or reputation in the mark, and also prove that someone else's unauthorized use of the same mark amounts to a misrepresentation, which means, in effect, a claim by the imposter that the goods or services they are selling are in fact made by the actual brand owner, and that this is causing or is likely to cause damage to the brand owner. That can all be difficult, time-consuming, and expensive, and it's particularly difficult for a relatively newly established brand. By contrast, registration of a trademark gives the owner the exclusive right to use the mark for specified categories of goods and services, and allows the owner to restrict others from registering the same mark in the same categories. Rob will discuss the protections available to holders of registered trademarks in greater detail in his section later on. But for the time being, I'll note that the bar to clear for a brand owner who wants to take action to defend a registered trademark is in most cases far easier to clear than that which the owner of an unregistered trademark must succeed in clearing. The protection given to a registered trademark takes effect for a period of 10 years from registration, but importantly, it's renewable after that first 10 years. Registered trademarks are limited by reference to territory. So trademarks registered by the UK's Intellectual Property Office can be enforced in the UK, those registered by the EU's IPO in the EU, etc. So it is important for the business considering registering a trademark to ensure all relevant territories are covered, and also that the classes of products and services for which the mark is registered are accurately and comprehensively identified at the outset. Trademark attorneys can provide support with that process of identifying the classes and territories. Once the trademark is registered, it is important to ensure that it is used, since registered trademarks can be cancelled for non-use. It's also important to ensure that the trademark does not lose its distinctiveness by becoming the generic term for the type of product, regardless of manufacturer. So examples of that include aspirin and bubble wrap, both of which originally had registered trademark protection, but have since lost it. While Xerox and Velcro are examples of brands that have run campaigns to steer users away from using their trademark as a generic term for the product. Moving on to think about patents. While trademarks are a form of intellectual property that will be relevant to any trading business, patents will only be relevant to businesses operating at the cutting edge of a particular technology. Patents give the owner legally protectable monopoly rights over an invention, an entirely new product or process, or an entirely new product element or step in a process, allowing that owner to use, make, and sell the invention themselves to the exclusion of anyone else for a period of 20 years. Patents only exist through registration. Before the invention has succeeded in being registered as a patent, businesses will sometimes use the patent pending notice to give others warning of the fact that a patent is being sought for the relevant invention, and accordingly that anyone copying it risks infringing the future patents once it is granted. However, it is important to note that patents pending notices must only be used once an actual application is in process, and in themselves, they do not create any legally enforceable negative right. Only once patent has actually been granted can the owner take legal action against copycats. Applications for patent registration are again territory specific and are made to the relevant patent office or the intellectual property office in the UK. In the UK, the applicant must prove that the invention is new, involves an inventive step, and is capable of industrial application, as well as that it's not specifically excluded from protection as a patent. The invention must not have been disclosed to the public before the application was lodged with the Patent Office. That would defeat the application. Software, in and of itself, is not capable of patent protection, but an inventive technical solution implemented using software is potentially patentable if it meets all the other general requirements and also the tests establishing for assessing software-based patents. Without going into the technical registration details requirements in detail, it is worth noting that obtaining a patent is complex. Whereas trademark registrations may take a few months, obtaining patent protection will take several years, and there is less certainty of success at the outset. It is time-consuming, labor-intensive, and expensive. However, the corollary of that is that once obtained, a patent is a potentially highly valuable asset. This is particularly true because the owner of a patent can prevent a third party from using the patented invention, even if the third party developed their own version entirely independently without copying the patent's owner. An important consideration for businesses working in the kind of areas where patentable inventions could arise will be whether it is better to rely on confidentiality in respect of a new invention or process by keeping it secret, or alternatively, to seek to take advantage through patent protection. The downside of registration is that, by definition, it means disclosing the relevant invention or process. If patent protection can be obtained, the owner will have the negative right to prevent others using the invention, but only for the duration of the patent protection, and after that, the invention will have been publicized and will be available for anyone to use. By contrast, while there is nothing to protect the proprietor of a trade secret from the risk of someone else independently coming up with the same invention or process, if no one is able to do so, and if the trade secret can be effectively guarded from disclosure, there is nothing to stop the invention remaining secret indefinitely. Now we have run through some key aspects of the main types of intellectual property. The next part of our presentation will consider how a business can go about identifying what intellectual property it has.
And one of the most appropriate ways of doing that is to undertake an IP audit. An IP audit is a systematic review of the intellectual property assets, including registered and unregistered assets, existing and future intellectual property that is owned, used by the business, or may be implemented in the future by the business. An IP audit will help you to identify existing and potential intellectual property assets. It will assess any issues around ownership of those assets, including, for example, if you've used third parties to develop works on your behalf. It will consider whether you have the appropriate assignment of IP into the business from that third party and identify any gaps in protection, which could include, for example, if your business has integrated open source software or third party software within its software solution, what are the implications of that for your licensing structure and the ownership of the developed software that you have produced. An IP audit also helps you to assess the risks that may be posed by such matters, and it will provide specific recommendations to help you best manage and protect and exploit those IP assets. It can also be used as part of any investment rounds your business may go through as part of the due diligence exercise. It would, part of that requires companies to look at what IP they have, is that IP owned by the business, and what value that has on the actual business valuation and asset valuation. So IP audits are an important a tool to play in, your business protections. And there's good news as well. IP audits can be part funded by the UK Intellectual Property Office. So we work with Innovate UK, and we've assisted clients in obtaining both Tier 1 and Tier 2 funding from the IPO. Tier 1 funding is for the actual IP audit itself. The IPO pays £2,250, which is inclusive of VAT, towards the cost of the IP audit, and the business is simply required to pay £750. And following the audit, what you have then is a full audit report for your business to implement. To be eligible for the funding, the business must be a micro entity or a small medium enterprise and have fewer than 250 employees with an annual turnover of less than 50 million. So that's quite a wide parameters in which funding is available. And the good news doesn't stop there. You can also then go on to apply for Tier 2 funding. And Tier 2 funding provides funding towards professional advice on progressing the IP strategy or implementing the recommendations from the IP audit. And that can include having things such as licensing terms or licensing agreements drafted, or the application for registrations to be made. What the IPO does is it matches the business's contribution up to a maximum of £2,250, inclusive of VAT. So, for example, if the work identified in the IPO audit was of a value of £5,000, then the IPO would pay £2,250 towards that, and the business would pay the other £2,250 towards it. So it's really a win-win for the business because you get a large portion of the costs paid for you, and you're also taking steps to put in the protections in place and exploitation strategies for your business. Now, Richard's going to look into those protection and exploitation possibilities in a little bit more detail.
It goes without saying that intellectual property rights are valuable assets for business and require protection. We've already discussed the merits of secrecy and confidentiality in this context. But equally, taking commercial advantage of owning intellectual property will often involve sharing the material protected by intellectual property rights with third parties, with customers or suppliers and other partners. This may mean allowing a franchisee to use the brand owner's trademark and copyrighted guides and manuals, or licensing software to a customer or a reseller. The owners of patents will often permit a third-party manufacturer to use their patents and the related know-how for purposes of manufacturing finished products for onward distribution. Equally, the creation of intellectual property for other businesses is itself a common commercial activity. For example, in the context of software development, or carrying out R&D, or producing marketing material or other content. It is crucial to ensure that suitable contractual terms apply at each stage of these various commercial arrangements to ensure that intellectual property is properly dealt with. Before the main contract is entered into, a suitable non-disclosure agreement, an NDA or confidentiality agreement, all of which means the same thing in this context, should be used prior to sharing any confidential information or intellectual property relevant content to allow such information and content to be used by the third party whilst restricting it from using it for any purpose other than investigating the proposed deal and from disclosing it to any third party. If your business is entering into a contract as the customer, you should ask whether the service that will be provided could involve the creation of intellectual property rights. If so, who will own them? The default position is that the supplier will own newly created intellectual property rights, unless there are express assignment provisions in the documents to transfer those intellectual property rights to the customer. If you as the customer want to own the new intellectual property rights, you may need to negotiate this provision. And you will also want to ensure that you have a license from the provider allowing you to use any pre-existing background intellectual property, which is owned by the provider and is necessary to allow you to use the new material. If the point of the arrangement is for you as a customer to engage a provider to design software or other content for your business's exclusive use, it will be particularly important to ensure that you get full ownership of the intellectual property rights embodied in the new material. Even if you do not require ownership of the new intellectual property rights, you can reasonably expect the supplier to take responsibility for providing you with new non-infringing content. This is typically backed up by an indemnity from the provider, which is a contractual promise that they will compensate you for any losses you might suffer if some third party brings a claim against you, arguing that your use of the material the provider gave you in fact infringes that third party's intellectual property rights. It is generally considered that a reputable supplier will bear that risk rather than leaving it with the customer, since the customer is not in a position to investigate how the intellectual property they are being provided with was actually created. If you are the supplier, the same considerations apply in reverse. You should ask whether you are willing to transfer any new intellectual property to the customer, or whether you, in fact, yourself need the right to continue to use it. If it is the latter, then you should ensure that the contract allows a license only. The supplier may also want to ensure that any material which the customer provides to them for inclusion in the finished product is supported by a corresponding indemnity, protecting the supplier against the risk of being hit with a third-party infringement claim in respect of its use of the material provided by the customer. A very wide range of commercial arrangements exist to enable the commercialization of intellectual property rights, from outright sale of intellectual property as an asset to intellectual property licenses, which may simply allow the licensee to use the owner's intellectual property for their own internal business purposes, subject to a license fee, or they can potentially allow the licensee to resell the licensed software perhaps in combination with the licensee's own products and services. Royalties generated from intellectual property licensing can then be used as a revenue stream for the property owner. If you want to discuss your plans for commercialization of your intellectual property, we in the commercial team would always be happy to talk this through. At this point, having discussed some main types of intellectual property and how they can be identified and commercialized, I'll hand over to Rob, who will discuss some of the points to consider for rights owners in respect of enforcing and protecting their intellectual property rights.
Morning, everyone. I'm Robert Brothers, and I'm a senior associate in the litigation team here at Meyerson. I've been working as a commercial litigator for around 7 years. And my practice covers a wide range of disputes, including contractual disputes, commercial agency claims, shareholder disputes, and of course, intellectual property work. So today I'm going to talk about IP litigation and its role in protecting your intellectual property rights and assets. I'll discuss some of the common pitfalls I see in practice, and then I'll move on to discuss trademark litigation and hopefully some interesting cases there. So jumping right in, let's consider the purpose of IP litigation. Its function is to address infringement of your IP rights. If you're a trading business, I'm certain you will have some form of intellectual property worth protecting. Think about your brand name and logo, which links your goods and services. The content of your website and promotional material, the products which might have a unique construction or 3D design, and your confidential information and trade secrets. Now, ask yourself, is any of that worth protecting? The answer, unsurprisingly, is yes, absolutely. Now, you might have protections in place already. For instance, you might have IP and confidential information separately defined in your T's and C's and other commercial contracts. You might have bespoke licensing agreements or NDAs setting out the parameters of how your IP may be exploited by third parties. You might have registered designs for your products or registered trademarks for your name and logo marks. And you might have also even used the IP audit facility, as Carla mentioned previously, to identify what IP you've got. And these are all really effective ways to know and protect your IP and can usually stop others from infringing your rights. But what if, regardless of all of that, your IP is being infringed? What can you do? That's where IP litigation comes in. You can enforce your rights typically by way of a cease and desist letter or letter before action to the offending party. If that doesn't work, you can start court proceedings and seek all manner of relief. There are various remedies you can seek, including damages, account of profits, injunctive relief, orders for delivery up, and publication of judgments. And by taking action, you safeguard your brand value and market position, and you also prevent dilution of your IP. You retain control over how your goods and services are represented, which preserves trust in your brand overall. And it also can bolster your negotiating power with respect to licensing, partnerships, and joint ventures, since IP that's protected and enforced can normally attract more favorable terms. So we're agreed that IP rights are important and worth protecting, and litigation has a role to play in that. However, there are just some common pitfalls for businesses to avoid when it comes to protecting and enforcing their IP rights, and these are just worth highlighting because they can be easily avoided. So firstly, not registering your IP properly or at all. For example, if you don't register your brand name as a trademark, then you leave yourself open for someone to copy your brand. And whilst you might still have unregistered trademark rights and rights in passing off, these tend to be limited in geographical scope and are in practice much more difficult to enforce than registered trademarks. Secondly, your IP registration might not be wide enough. If you've got an IP registered right, so you must ensure that it's updated regularly in accordance with the needs of your business. So, for example, with trademark registrations, you have to specify which classes of goods and services will be covered by that mark. For example, a business that sells electrical goods would choose the relevant trademark class that best fits that activity. But if the business then expands into other areas, say it started offering electrical fitting services, that activity is unlikely to be protected by its existing trademark registration unless it's covered by a specific class. So it's always worth double checking whether your trademark needs to be updated to fit the needs of your business at the time. Thirdly, reliance on Companies House in place of IP registration. So from time to time, I have clients asking, well, I have my company name registered on Companies House. Doesn't that mean my company's name is trademarked? And the short answer to that is no. Companies House isn't a register of trademarks or any IP right. And having your name registered on Companies House doesn't really offer you any real protection against trademark infringement. To protect your brand name, you have to register it as a trademark at the Intellectual Property Office. Fourthly, the contract doesn't specify who owns the IP, and this is something that Richard touched upon, and it's particularly relevant to creative works such as written material or even bespoke software and computer programs. And the general rule is that the author of the work has first ownership of the copyright, and that's even where the author was hired to supply the work. And that can arise with consultancy agreements and supply agreements. And if the contract's silent on ownership, it's automatically presumed that the author of the work retains ownership in the copyright, and that's even if they've been paid for the work. And that can have serious consequences in terms of the customer's ability to exploit the work and can lead to challenges down the line. So the safest course is for the contract to specify who will own the copyright once the work is created and supplied. And finally, delaying action. Your IP rights will generally be harder to enforce if you don't take action right away. The limitation period for intellectual property claims in the UK is 6 years from the date the cause of action accrued. If you miss limitation, you might not be able to bring a claim, even if there is a clear case for infringement. So it's really important to take action as soon as you become aware of any infringement. And from a practical level, if you do spot an infringement and you think that that's got the potential to damage your business, then it's best to take immediate action to cauterize that risk. Because the last thing that you want is to delay and be faced with either a limitation argument or alternatively an argument that you somehow acquiesced and allowed the infringement to continue unchallenged, and that can weaken any claim that you've got. So those are some of the more common pitfalls that I've identified in practice. And now on to hopefully the more interesting side, the types of dispute I see in practice and some key takeaways. So my area is mainly focused on brand protection. So we're talking about trademark and passing off claims, and I usually help companies enforce their trademarks if they discover that that's being infringed, and I often help companies defend claims also. So generally the scenario is that a business has a brand name and discovers that another business is using the same or similar brand name for the promotion of their goods and services. Now, if the business has a registered trademark, they have various statutory protections under the Trademarks Act 1994, and that provides for 3 rights of action, which are summarized on the slide here. So the first is where there's a registered trademark and a third party is using an identical mark for identical goods or services. Secondly, where a third party is using an identical or similar mark for similar goods and services, and that generates a likelihood of confusion. And finally, the catch-all provision is where a third party is using an identical or similar mark for goods and services which are not necessarily identical or similar, but nevertheless take unfair advantage of the distinctive character of the mark. So you can see there's quite a wide statutory protection for registered trademarks, and even where the goods and services aren't similar, it's enough for the rights holder to show that a third party is taking unfair advantage of its mark, which is essentially its goodwill and reputation in the market. There was actually a recent case on this very point between Tesco and Lidl, and you might have read about it in the news recently. Lidl successfully argued that Tesco had infringed its logo, which is displayed here on the slide. And you can see that it's a blue box with a yellow circle with some text overlay. And essentially, Tesco was using that shape and coloring for its Club Card Prices loyalty scheme. And the court found that the marks were similar and that Tesco had infringed Lidl's trademark because it took unfair advantage of the reputation of Lidl's marks by suggesting that Tesco's prices were the same or lower than Lidl's for equivalent products, and that was deemed detrimental to the distinctive character of Lidl's marks. And the key point, for me at least, is that the court's rationale for infringement was that Tesco's use of the sign created a link in the mind of the public where the signs were at least similar, albeit overlaid with different text. The court accepted there was a risk that consumers would reach the conclusion of price equivalence. But saying that, trademark protection isn't absolute, and it's important to note that the legislation isn't designed for one party to have an absolute monopoly over words, especially where those are commonplace and not distinctive. And a case that recently illustrates that is the Easy Group and Easy Live auction case. And you'll know of Easy Group's brands. The most famous one that comes to mind is EasyJet or Easy Hotel. And Easy Group have in recent years brought claims against various parties who trade using the name Easy, and they've been pursuing this litigation quite aggressively. And you may have read on the news that they recently sued the band Easy Life, who then subsequently changed their name to Hard Life as a result of the escalating costs of the litigation. But the latest Easy Group litigation, and one that I find quite interesting, was Easy Group's claim against Easy Live Auction, which is an online auction bidding platform. And one of the things that Easy Group tried to argue was that Easy Live's marks and services were similar, and that as a result, that would cause confusion in the minds of the public. However, the court held that the marks were only moderately similar and that the signs themselves were conceptually different. And the court held that the presence of the word easy in and of itself would not give rise to a case of infringement. And there was a clear emphasis here in the court not allowing parties to obtain a monopoly over ordinary everyday words. And there has to be something more to establish a likelihood of confusion. So I'll just wrap up here by running through one of the cases I've worked on, which I think is pretty interesting and hopefully ties everything together. It was a trademark case, and it involved a spat over social media. and unjustified threats of infringement. The scenario was my client was a food manufacturer and about to launch a brand of donut flavored protein bars under the name Prodo. And apparently donuts are popular among bodybuilders. So I guess the client wanted to capitalize on that. When the client was about to launch its new product, another donut company called Project D contacted my client asserting that it had infringed its brand name and demanded my client stop selling the Prodo bars immediately, or they would sue for infringement. Unfortunately, Project D also decided to copy this communication to all of my clients' manufacturing partners, stockists, retailers, and social media influencers. And as you can imagine, that caused no shortage of chaos for my client, as well as completely kiboshing its product launch. Now, Project D did have a registered figurative mark for its logo, and the question was whether that trademark had been infringed by my client's packaging. And the marks are shown here on the slide, side by side. So what do we think? Somewhat similar. There's a pink background, similar sort of cartoonish bubble font, both promoting donut or donut flavored food products. However, when you actually look at the words themselves, Project D versus Prodo, they're different, both orally and how they're spelt. And yes, the logos are in a pink background, but that's hardly distinctive, especially when one thinks of donuts or confectionery products. The end products are different. One was donuts and the other protein bars, so arguably a different target market. And ultimately, the chances of there being confusion or association between the brands was low. And in my view, too low for Project D to establish a case in trademark infringement. So what did we do? Well, we wrote to Project D demanding their immediate retraction of their statements and a public apology for accusing our client of trademark infringement. And if they failed to comply with that, we threatened to issue an action pursuant to the Intellectual Property Unjustified Threats Act 2017. And that's actually quite an interesting piece of legislation that allows those accused of trademark infringement and threatened with a claim to bring a counteraction if that threat is shown to be groundless. And happily, it worked on this occasion. Project D withdrew its threat and published a public apology on its website and across all of its social media channels. And that was really important for the client because not only could it relaunch its product and sell it without interference, its reputation in the market was also restored. I think one of the most important lessons here is that whilst a rights holder is entitled to protect its trademark and enforce it, they also have to be careful not to overstep and make threats which could land them in hot water, which happened to Project D. That's why we'd always recommend businesses take specialist legal advice before advancing claims. So that's the end of my section and the webinar. We hope you found it useful. And as you'll appreciate, there's so much to speak about. I'll hand back to Carla just for concluding comments and any questions.
Thanks, Rob. Yeah, just thanks again for everyone for joining us. If there are any questions, if you pop them in the Q&A section, and I appreciate we've overrun slightly because of the delay, but we will look over those questions and respond personally to you. Thank you.